Good afternoon, everyone. Thank you for joining us today. We're going to give it just a couple of minutes to let individuals trickle into our virtual meeting space today before our conversation gets started. Thank you, everybody. Give us just a few more moments. Well, I see a number of individuals have already joined us today, so we're going to go ahead and get started. Thank you for joining us today for a presentation on special immigrant juvenile status presented by our partners at the Immigrant Legal Resource Center. Before we get started, I do have a number of housekeeping items that I want to go over with you before Rachel, who is our key presenter today, gets started. Just wanted to share with everybody that this webinar is being recorded and a copy of today's presentation along with the PowerPoint presentation will be shared with all of you at the email that you use to register in the next couple of days. Throughout the presentation, we encourage you to ask any questions by utilizing the Q&A feature. We have reserved some time at the end to answer any of your non-case specific questions. We also have closed captioning available. So if you hover at the bottom or at the top of your screen, you'll be able to open the closed captionings for today's webinar. We'll be dropping links and resources throughout the presentation into the chat feature, and we encourage you to click open and save. All of those resources will also be shared in the follow-up email. With all of that housekeeping items said, I'm really excited to bring on Rachel from the Immigrant Legal Resource Center, who will guide us through today's conversation on special immigrant juvenile status. Welcome, Rachel.
Thank you so much for having me, and good afternoon to everyone. Thanks for joining us. So, as Alonso said, my name is Rachel Prandini. I am an immigration attorney with the Immigrant Legal Resource Center. If you're not familiar with our organization, we're a national nonprofit resource center on immigration law and policy, and we're based in the Bay Area here in California. Though we also have offices in the Central Valley of California, 3 offices in Texas, as well as an office in Washington, D.C. And we do kind of 3 different types of work or buckets of work. We do policy work at the local, state, and national level, advocating for fairness to immigrants. We do civic engagement work with immigrant communities. And then we do a lot of trainings and technical assistance and written resources for legal professionals, as well as other advocates working with immigrant populations. For example, this type of webinar that we're doing today. So I hope you find it helpful. And also at the end of today's training, I will have some links included to various of our written resources on SIJS, the topic of today's webinar, which are available for free on our website. So I will be directing folks to those as well. So our plan for today is to spend the next 45 or so minutes discussing special immigrant juvenile status, what it is and what benefits it provides, what the eligibility requirements are, and how someone might be able to meet them. And I'll provide an overview of the application process and give you as much of a sense as possible of the timing of that process as well. And then we're going to be talking about how to access on-campus legal services, which can help you figure out if you or someone you know is eligible to get immigration status through this particular path to status. So that's our plan for today. Before we jump into the content of the training, I do want to do a quick poll and ask for people to weigh in with their experience. So this is a very straightforward, simple polling question, which is just, have you ever heard of special immigrant juvenile status? Yes or no. So if folks could take a moment to vote, that'd be great. Okay, see, a lot of people have voted, and it's almost 50-50 people who have heard of it or not. So that's great. For those who have heard of it, if you would be willing to share in the chat box one thing you remember about it. So if you're familiar with it, what stood out to you about it, or what's even just like a word that you remember that you associate with it. And yeah, while people are finishing with the poll, we can see what comes in on the chat box. All right, so far I'm not seeing anything in the chat box about what you remember about it. So, I mean, it is complicated. Maybe it's hard to remember much of anything about it other than the name. But I'll jump into the content, but if as I'm talking, you're remembering things about it, chat box is disabled, it says. Okay, now the chat is open. Okay, that was actually the issue. So yeah, someone said they must be under 21. That's right. Confusion with asylee versus SIJS. Yeah, so those are different paths to getting immigration status. Minors without a companion as people who might be eligible. Yeah, these are all. Court order needed. Yes, and we're going to talk a lot about that. Parent left the country. Yeah, sometimes, and we'll talk about this, SIJS eligibility is because someone doesn't have a parent here. Starts in state court. Doesn't qualify for advanced parole. Yes, that's right. Okay, wow. Okay, so people actually remember a lot about it. This is great. Okay, I'm going to, let's see, I think that the poll is all closed out now. If you can double check that for me, Alonso, that'd be great. So let's jump into talking about SIJS, what is it, and what are its main benefits? So just for a little bit of history, Special Immigrant Juvenile Status was created in 1990 through federal immigration law. And it was created after advocacy that was led by the Santa Clara Child Welfare Agency. So it has kind of its roots here in California in the child welfare system. Because of that, it's unique in immigration law in a couple of ways. One is that it does consider what's in the best interest of the child. And that is a legal standard, best interest of the child, that's used in any other system, legal system that impacts children, but otherwise is nowhere listed besides SIJS in our immigration laws. So because of its roots in the child welfare world, it pulled in this concept of what is in the best interest of the child. We'll talk more about that when we look at a little bit more of the eligibility requirements. It's also unique in immigration law, as a few people shared in the chat box, in that it starts out in state courts. So, you know, broadly speaking, immigration law is all federal law. So it's unusual for state courts to have a role in federal immigration process. But SIJS begins and must begin in a state court system. And we'll talk a lot more about how that plays out. SIJS provides a pathway to a green card for young people who have been abused, abandoned, or neglected by a parent. Those terms, abuse, neglect, and abandonment, are legal terms, and they have legal definitions under California law. And we're going to talk about the kind of range of situations that they might cover a little bit later in this training. So just keep in mind, abuse, abandonment, or neglect. We are going to break that down and give some examples of what that might actually look like. And it may be more broad than what you expect. This path to immigration status, again, as people mentioned in the chat box, it's only available to young people while they're under the age of 21 and unmarried. So it's really just for, as the name indicates, juveniles or young people. And it requires that the young person be in some type of state juvenile court proceeding. So sometimes young people already have a case in juvenile court. For example, if their parents were getting a divorce and the family court made a custody order for them, that might work as the juvenile court case that they already have open. In other cases, they may be eligible to open a case in juvenile court, for example, to file a case in probate court to get a guardianship. When they meet with an immigration attorney and the immigration attorney says, you might be eligible for SIJS, we can actually open a case in state court. So it can happen different ways. So don't just rule out your own eligibility if you're thinking, well, I'm not involved in any kind of state court proceedings. And we'll talk a lot more about how that might play out in California. Whatever juvenile court the young person has a case in front of, The judge in that case has to make 3 specific judicial determinations in an order that the judge is going to sign, and that order is required for the young person to be eligible to apply for SIJS with the Federal Immigration Agency. So looking at this in a visual way, we can think of the path to SIJS and lawful permanent residence or a green card as a 3-step process. So the first step, as I mentioned, is unique in the world of immigration law in that it takes place in a state juvenile court. At that stage, either a case is open in juvenile court or one may already be open, and then in that case, a request to the state court judge to make an SIJS predicate order is made. If the judge signs the order, then the person can go on to step 2 and file their petition for SIJS with U.S. Citizenship and Immigration Services. That's the federal agency that will just adjudicate the petition for SIJS. If that is approved, the petition for SIJS, then that creates eligibility to apply for adjustment of status to become a green card holder. Because of a shortage of visas for special immigrant juveniles, there is a long wait between steps 2 and 3 here on the screen. And originally that long wait only impacted young people from El Salvador, Guatemala, Honduras, and Mexico. But currently it impacts all young people who are seeking a green card through SIJS regardless of their country of origin. We'll talk a little bit more about the visa backlog later in the training. But you'll notice that there is this asterisk at step 2 because of this. So because there is now this long wait time between steps 2 and 3, when originally there was not, this is in recent years that there's been this big wait time, USCIS, that agency that adjudicates the petitions for SIJS, announced a policy in 2022 that allows young people who are granted SIJS to also be given deferred action. Deferred action provides protection from deportation. So if you're familiar with DACA, Deferred Action for Childhood Arrivals, this is the same type of discretionary protection from deportation that's being granted here to special immigrant juveniles that is granted in the context of DACA. For special immigrant juveniles under this policy, if deferred action is granted, it's granted for a period of 4 years. So actually longer than DACA. And it creates eligibility to apply for work authorization for that whole 4-year period. So in other words, someone, if they're successful in step 2, getting their I-360 petition, that's a petition for SIJS approved, they may also be granted deferred action, and then they could get work authorization for a 4-year period while they wait to get to step 3. And we're going to break this down more. This is just like give you the big picture overview of what will this process look like in 3 steps. So one of the most immediate benefits of SIJS currently is that if it's approved, and the SIJS petition should be approved or denied within about 6 months of filing. If it's approved, it makes the young person eligible for deferred action and then to apply for work authorization. So it can be, relatively speaking to other paths to getting immigration status, it can be a relatively quick way to get work authorization and protection from deportation in the form of deferred action. In terms of the longer term benefits of seeking special immigrant juvenile status, most importantly, it puts you on the path and kind of opens the door to eligibility for a green card. Having a green card allows you to work, to be eligible to apply for federal financial aid, and to live, of course, without the fear of deportation. It is really the best immigration status someone can achieve short of US citizenship. And once you have a green card, you can apply for citizenship to become a US citizen if you desire that after 5 years, so long as you meet the other eligibility requirements. There are, as we think about SIJS and think about potential other immigration options, like someone mentioned asylum, or if you've heard of U visas or T visas, there are a couple of drawbacks of SIJS. So currently, there is this long wait time between steps 2 and 3 that we saw on the big picture slide. So before you can actually apply for your green card, there is a multi-year wait. And this wait time between steps 2 and 3 will continue to get longer unless and until Congress fixes the law. So this can be a very long process until you obtain secure immigration status. Although, as I mentioned, it could be a relatively short process to getting deferred action and work authorization. Another drawback that's important to keep in mind with SIJS is that the child or young person who's applying cannot include any of their family members in the application. So that is possible in some other humanitarian paths to status, like the U visa or the T visa. You can include your family members, but for SIJS, it's just for you yourself to get immigration status. And on top of that, there is actually a bar on the young person who obtains SIJS ever being able to help their parent get immigration status. And that's true even if only one parent, for example, abandoned you, and it's important to you to be able to help your other parent get immigration status. So this can be a big drawback for some people, and it's important to understand that limitation and definitely discuss it with your immigration attorney if you're considering pursuing this path to immigration status. Thinking about SIJS and other immigration options or issues, bear in mind that it is possible to pursue SIJS when you already have DACA, or for example, if you're already a derivative on a pending U visa. Of course, you can also apply for SIJS when you're undocumented. If you have already found another immigration application like DACA, just be sure that the information that you're including in these different applications is all consistent. And note that if you do already have DACA, you may still want to apply for SIJS because unlike DACA, it does put you on that path to getting a green card. Just a quick note that it is also possible to pursue SIJS when you have a removal order from the past, or in other words, you've been ordered deported before, or maybe when you entered at the border, you were given a removal order. Just really important to share that information with your immigration attorney so that they can properly address it. Okay, so that was kind of our overview. What is SIJS? What's the big picture process? What are the benefits and maybe some drawbacks? Now I want to talk in more detail about the eligibility requirements for SIJS. So currently for a young person to be eligible for SIJS, they do have to be under 21 years of age at the time that they file the SIJS petition with USCIS. They also have to be unmarried, both at the time that they file their SIJS petition with USCIS and until USCIS has issued a decision on the SIJS petition. In addition, the young person has to have been either declared dependent on a juvenile court or the juvenile court must have made some type of custody order for them. So again, this one can be confusing. Why would the young person need to be in juvenile court proceedings if they weren't already? And what do juvenile court proceedings have to do with someone's immigration case? So as I mentioned at the beginning, the kind of history of SIJS is that it was created to help young people in the foster care system. These young people were then, by definition, already in juvenile court proceedings. So over the years, as the eligibility requirements for SIJS were broadened, and many young people who had no relationship or engagement with the foster care system are now eligible for SIJS, this juvenile court requirement was kept in, though. And that's because juvenile courts have expertise in issues of child welfare and child custody, and immigration authorities do not. But now different types of juvenile court proceedings can work here, not just foster care type of proceedings. So for example, if you go to state court and you get a guardian appointed, and a guardian is basically someone who steps into the shoes of a parent, that can be a juvenile court proceeding for SIJS purposes. So that would work for SIJS. Or if you live with one parent and that parent that you live with requests full custody of you through family court, that can be a juvenile court proceeding that works for SIJS. So you can see it's much broader than foster care now. And we'll talk about this more, but I also want to make the point that these are types of cases that you might be able to open in California, guardianship or family court custody, if you otherwise meet the eligibility requirements. So again, you don't already have to have an existing case in juvenile court. Okay, so we'll talk a little more and I'll show some examples of how things might play out in juvenile court, but these are our first three eligibility requirements, and there are two more. So whatever juvenile court the young person has a case in, that juvenile court judge also has to make these following two, we call them judicial determinations. So Those are first, that reunification with one or both parents is not viable due to abuse, neglect, abandonment, or a similar basis under state law, and that it is not in the young person's best interest to be returned to their country of nationality or last residence. So numbers 3 through 5 on this list. So 3, which is about dependency or custody in the juvenile court, and 4 and 5, which are about reunification with a parent and best interest. Those are the 3 judicial determinations that have to be included in an order signed by a judge that allows the person to then apply for SIJS with the Federal Immigration Agency. So we're going to look at each of these in a little more detail as we think through the eligibility process and requirements for SIJS. So starting first with the age and marital status requirements. So a young person has to be under 21 when USCIS receives their petition for SIJS. Because in order to be eligible to file your petition for SIJS with USCIS, you already had to have some proceedings happening in a state court. Really, the application process has to start far enough in advance of your 21st birthday in order for you to go through the process in state court, put the application together, and get it to USCIS prior to the age of 21. So there is a lot of time sensitivity to getting legal status through SIJS. So if you're still under 21, you're thinking about SIJS, you should get screened as soon as possible. The more time you have before you turn 21, the better. And again, we'll talk more about how to access on-campus legal services at the end of the presentation, but really would encourage you, if you're under 21 and you think you might be eligible, to just make an appointment as soon as you can. If you're over the age of 21 and no longer, because of that, no longer eligible for SIJS yourself, consider, do you have a younger sibling or a niece or a nephew or a family friend who you're thinking about who might qualify for SIJS? Because if they might be eligible as well, again, it's time sensitive. They need to know that, and they need to go meet with an immigration attorney as soon as possible. Okay, so that's our age requirement. In terms of marriage, you can't be married when you're applying for SIJS or get married while the petition for SIJS is pending. It is okay to get married if your I-360 petition, that's the SIJS petition, is approved by USCIS. And that is a change. Prior to 2022, young people had to stay unmarried all the way until they got their green card, so until they were through the entire process. But that has now changed as of spring of 2022. And now once step 2 is completed and your I-360 petition is approved, it is okay to get married. But you definitely should not get married while your SIJS petition is pending. Okay, so then as promised, I want to talk a little more about the juvenile court's involvement in SIJS, since this part can be mystifying. So this is number 3 on the list of eligibility requirements. So the young person has to either be declared dependent on a juvenile court, or they have to have been placed in some kind of a custody situation by the court. In California, there are essentially 4 different types of courts that can act as juvenile courts for purposes of making this SIJS order that is needed to apply with the Federal Immigration Agency. So this includes our dependency or child welfare courts. This, in that type of setting, that is when a young person would have been removed from their home because of alleged abuse, neglect, or abandonment, and potentially placed in foster care or placed with a relative or placed with one parent. Those are types of proceedings that meet this requirement because the child is made dependent on a court. In California, this also includes our delinquency or our juvenile justice courts. So those courts get involved, for example, when a minor is charged with an alleged violation of the law. That's when someone under the age of 18 is being charged with a violation of the law. So in these types of proceedings, dependency, child welfare, and juvenile justice courts, these types of cases are only initiated by the government. So if you don't have one of these cases open, generally you would not be able to open this type of a case. So I'm really just mentioning this more to say, if you happen to have one of these types of cases open, it is possible to just ask for that the SIJS judicial determinations that you need in that open case. And that is a relatively simple process if you meet the eligibility requirement. If that's not the case for you, you don't already have that kind of juvenile case open, then you want to consider that it is possible to open a case in family court or probate court in California. So if you think you meet the eligibility requirements for SIJS, but you don't already have a case in a state juvenile court, an attorney can help you open a case in family or probate court, in which then you could ask the judge to make the SIJS determinations for you. So family courts in California typically make custody orders about children under the age of 18 and decide which parent will have custody. It's possible to request the SIJS findings order from the judge if one parent gets sole custody of the child. Family courts in California can only make custody orders for young people when they're under the age of 18, though. So this is only an option for young people who are still under the age of 18. However, our probate courts in California can appoint guardians for young people up until the age of 21. So as I mentioned, guardians are typically caregivers who step into the role of parents when parents are either unavailable or unwilling to care for their child. And it is possible to request the SIJS predicate order in guardianship proceedings once a guardian has been appointed. For young people who are over the age of 18 and under 21, in certain circumstances, the probate court can even appoint one of your parents as your guardian and then issue the SIJS predicate order. So these are the 4 types of courts that typically make the SIJS predicate order for young people. Maybe you already have one of these kinds of cases open, or maybe you don't, but maybe it's possible for you to file the case. And then you can also, through that case, get the SIJS predicate order. Okay, then moving to the next eligibility requirement for SIJS. So whatever state juvenile court the young person has a case in, that judge will have to make a determination that the young person can't reunify with one or both parents. So the first point I want to make about this is that this means that young people who live with one parent or are still in a good relationship with one parent, but have been abused, abandoned, or neglected by the other parent are eligible for SIJS. It doesn't need to be the case that reunification is not viable with both parents. So maybe you have a supportive and loving parent who raised you and your other parent has been out of the picture, or your other parent was abusive in the past. That could be enough to be eligible for SIJS. So really keep in mind that it doesn't have to be both parents, just one parent. The other point that I want to make about this is that whatever state juvenile court is making these findings for you, that state court is going to look to state law definitions of abuse, neglect, abandonment, and similar basis. So they're going to be looking to California law here. There are no federal definitions, and state courts are really asked to apply their own state law when they're making these determinations. In California, looking at our California law, abuse is defined to include physical harm or substantial risk of serious physical harm, emotional harm, and it can also include things like allowing a child to witness domestic violence. Neglect is harm or risk of harm because of the parent's failure or inability to supervise or protect their child. And abandonment generally means leaving a child without communication or support. And this definition of abandonment can include the death of a parent, depending on exactly what happened. So I'll give an example of that a little later. So because the state juvenile court will make this determination based on California law, keep in mind that even if you wouldn't think to describe your situation as one where your parent abandoned, abused, or neglected you, it might actually meet the definition of one of those things under California law. And that's what matters for SIJS eligibility is, does it meet the definition? If it meets the definition, you could be eligible to get legal status through SIJS. So it's really important that you talk to an on-campus legal services provider about your situation in case you might actually be eligible for SIJS without knowing it. And I also just want to mention that getting this determination from a state court judge that one of your parents, or one or both of your parents, has been abusive, neglectful, or has abandoned you, generally that does not negatively impact your parents' parental rights or subject your parent to some kind of liability. It's a judicial determination that you're going to use in your own immigration process. If you have concerns about this, this is also definitely something you want to discuss with an immigration attorney. So discuss that with your legal services provider when you go in for a screening. Okay, I want to talk through some examples, kind of sample stories of young people who might be eligible for SIJS to ensure that you get a good sense of what it means in California for SIJS purposes to not be able to reunify with a parent due to abuse, neglect, or abandonment. Before I kind of walk us through these, I just want to give people a heads up that there are descriptions of domestic violence, child abuse, and parental abandonment in these examples. So if that's something that you'd rather not listen to, do what you need to do, take care of yourself. So with that, let's consider first the example of Eric. So Eric migrated to the United States on his own at the age of 16. In his country of origin, his father regularly beat up his mother in front of him. His father never hit him, but would threaten to hit him if Eric tried to intervene to help his mom. So Eric may be eligible for SIJS based on the domestic violence between his parents and the threats of harm he experienced, because a juvenile court judge could determine that that fits the definition of abuse under California law. Another example is Christina. So Christina came to the US with her dad when she was 7 years old. In her country of origin, her mom regularly hit her with her hands or a belt. Her mom struggled with alcohol abuse and was violent with Christina anytime she drank. Christina may be eligible for SIJS based on the abuse she suffered at the hands of her mother, which a juvenile court judge in California may determine fits the definition of abuse. Then we have the example of Karen. So Karen's parents brought her to the US when she was 12 years old. When she was 14, her father, who was her family's breadwinner, passed away. He didn't leave a will or inheritance. Karen's mother struggled to provide for the family in the aftermath. Karen may be eligible for SIJS based on the death of her father, which a juvenile court judge might say fits the definition of abandonment. And I just want to point out here that, even though the father didn't intend to abandon his child in this example, simply the death of the parent can be abandonment under California law. So just be thinking broadly about this. Okay, and then as a final example, we have Roberto. So Roberto came to the US with their mom at age 5. They have not received any support or care from their father since migrating, other than a few brief phone conversations. Roberto may be eligible for SIJS, as a juvenile court judge may determine that they cannot reunify with their father due to abandonment. So here's an example of abandonment where maybe there was intent on the part of the parent to abandon. That may fit the definition of abandonment, but also it's not required. So that's how death might fit the definition of abandonment as well. So those are just 4 sample life situations that might, in which a young person might be eligible for SIJS. But obviously everyone's story is different. And this is really just to get you thinking about what types of situations might lead to eligibility for SIJS. Okay, and then the last eligibility requirement on that list of 5 eligibility requirements for SIJS has to do with whether or not it's in the child or young person's best interest to be returned to their country of origin. And just like with the question of reunification with one or both parents, here state courts also look to state law on best interest factors. So in California, what's in the best interest of a child, we say, is defined by the young person's health, safety, and welfare. So where will the young person's health, safety, and welfare be best? And so the state court judge is actually asked to make a holistic comparison between the child's life here in California and what it might be in the country of origin if the child was forced to return to the country of origin. So the court can consider things like conditions in the country of origin, potential caregivers or lack thereof in the country of origin. Like, does this young person even have any family anymore in their country of origin? Is there an adult who can take care of them? The court can look at the young person's physical safety, both in California and in the country of origin, whether the young person speaks the language in the country of origin, whether they're going to have access to education and the opportunities that they're pursuing here in California. If they need any special services like medical services, for example, could they access them here versus in their country of origin? So for example, a young person who maybe has no potential caretaker in their country of origin, has lived in the US and is pursuing their education here, while perhaps there would be safety concerns in the country of origin and maybe an inability to pursue their education in the same way. So a court would look at those things and compare. And a court in that situation would likely say, no, it's in the child's best interest to stay here and not to return to their country of origin. So those are the eligibility requirements for SIJS, including those 3 judicial determinations that a judge has to make about dependency or custody, reunification not being viable with a parent, and what's in the best interest of the young person staying here or going back to the country of origin. In terms of the different roles played by the state juvenile court versus the federal immigration agencies in SIJS, so hopefully by now it's clear that state juvenile courts play an essential role in that the juvenile court order is something that you have to have before you're even eligible to go on to the step where you apply with the federal immigration agency. So it's a critical role, but the state juvenile court doesn't grant the young person any kind of immigration status. And getting the order from the state court isn't a guarantee that the young person will get immigration status. The state court judge is just making determinations about best interest, reunification, and the child's custody status. Once the state court does that, then the federal immigration agencies will ultimately decide whether the young person will be granted SIJS, and following that, whether they meet the requirements for adjustment of status to become a green card holder. So as a takeaway, if you're under 21, you're unmarried, you don't live with both parents, please get screened, as you might be eligible for what is a very time-sensitive path to getting immigration status. Okay, to wrap up, I want to provide an overview of what the application process actually looks like and what the timing might be like for these different stages. So here's kind of our broad overview of the process again, broken down into those 3 steps. So to give you a rough idea of the timing, and this really is a rough idea because it can be different in every case. If you don't already have a case open in state juvenile court, and you're going to work with an attorney to open a juvenile court case and then request the SIJS predicate order, that process will take approximately 2 to 6 months. And 2 months would be very fast. That is basically if you're about to turn 21 and the whole process has to be expedited. That would be on the very fast end. More typically would be on the around 6 months end of that time period. Once you get your SIJS predicate order from the state court, you get to go on to step 2. When you file the petition for SIJS with USCIS, USCIS is actually required to issue a decision within 180 days. They don't always hit that mark, but they get pretty close. And so it's about 6 months until you'll get a decision on your SIJS petition. If it's approved, the SIJS petition is approved, USCIS may also grant you deferred action. And often they do that at the same time that they approve your SIJS petition. The deferred action grant, they say, is discretionary. So they don't say it's a guarantee like, oh, if your SIJS petition is approved, definitely you get deferred action. However, they are granting it in, more than 95% of cases right now. So most young people are getting If their SIJS is approved, then they're also getting deferred action as well. Once you have been notified that you have deferred action, you can file your application for work authorization. And then talk to your attorney about when you get to that point, ask your attorney about what the processing time is like to actually get your work authorization from that, because it can fluctuate. Then for step 3, a young person who has SIJS will be eligible to file their application for adjustment of status. It'll be years after filing the SIJS petition. The actual date and the timing of it is determined by something called the visa bulletin. And that is a monthly bulletin that's put out by the State Department that shows basically how backlogged all the different visa categories are. And this is complicated, this area, in terms of visa backlogs and all that, but it is a multi-year wait for sure right now, unless and until Congress changes the law. And you can talk more with the immigration attorney who you meet with about, a sense of how many years it might be, but just know that this will be multiple years. So you got to be in it for the long haul in terms of until you actually get your green card. So as we talked about, the juvenile court process itself will look different for every person. Some young people already have a case in juvenile court. Others are going to need to open a case. And I'll just say the most common type of case for young people to open in this situation is a guardianship in probate court, asking the court to appoint a guardian. And this is possible until age 21 in California. So that aligns with the SIJS eligibility requirement. So as long as you're under 21, this may be an option for you. The next step, the SIJS I-360 petition, that form I-360 has to be submitted along with the order from the juvenile court. And it should include the facts, or in other words, the reasons why the juvenile court judge made each of the 3 judicial determinations. So for example, the judge said reunification is not viable with the young person's father because of abandonment. Then it should have a couple sentences describing, the young person has not lived with their father since they were 8 years old, and their father has made little to no effort to support or stay in contact with the child. So that information needs to be in the order that's going to go to USCIS. With the I-360 petition, you also have to include evidence of your age, just to demonstrate that you're under 21 when the petition is received by USCIS. So this I-360 petition is always filed with USCIS, even if the young person's in immigration court removal proceedings. And there's no filing fee for this SIJS petition. And as I mentioned, USCIS is supposed to issue a decision on it within 180 days of it being filed. With the approved petition for special immigrant juvenile status, if you get your approval at step 2, then that creates eligibility, the underlying basis to apply for a green card. There are a few other things that are required, though, to actually be eligible for a green card. So first, the young person has to be admissible to adjust status. And admissible is this concept in immigration law that describes someone who doesn't trigger any of a long list of things that could stop you from getting a green card. This includes things like convictions for many types of crimes, adult convictions for many types of crimes, prior immigration violations, although a lot of those don't apply to special immigrant juveniles or are waivable, certain diseases, if they believe someone's likely to become a public charge, although that also does not apply to special immigrant juveniles, and other types of certain conduct that the Federal Immigration Agency views as bad, for example, drug trafficking. So if someone is inadmissible, it blocks them from being able to get a green card unless they're eligible for a waiver. Thankfully, many of the grounds of inadmissibility do not apply to young people with SIJS, in recognition that this is a humanitarian form of protection for young people who have experienced parental maltreatment. However, keep in mind that the crimes-related grounds of inadmissibility do apply to special immigrant juveniles, and you cannot waive them with the special SIJS waiver standard. So that's one of the things in this long wait time before you can actually get your green card that you really have to keep in mind. And many kinds of adult convictions can make you inadmissible. And what that means is then you wouldn't be eligible to get your green card. There is one piece of good news, though, which is that juvenile delinquency adjudications, which are, when a young person who is a minor is charged in juvenile court with an alleged violation of the law, if they get a juvenile adjudication from that, those are not considered convictions under immigration law. So that's good news because most of the criminal-related provisions of immigration law are only triggered by a conviction, and juvenile delinquency is not considered a conviction for immigration purposes. So all that is to say that even if you have a juvenile record, you are most likely still eligible to get a green card through SIJS. Definitely share this with your immigration attorney, but it's not gonna, in most cases, it's not gonna bar you from getting a green card. In addition to the young person having to demonstrate that they are admissible, or if they're inadmissible, that they're eligible for a waiver, there are two additional requirements in order to be granted a green card. First, they have to demonstrate that they merit a favorable exercise of discretion. And that's because green cards are considered discretionary. So for discretion, if a young person has any negative factors in their case, and some factors that are viewed negatively include a juvenile record, especially ones that are for sex offenses or violent offenses, or drug-related offenses, or any alleged gang involvement. That's an example of some of the things that are viewed negatively. So if a young person has any negative factors in their case, they will need to file positive evidence to balance it out. Essentially, you're trying to demonstrate that the good in your case outweighs any negative elements. And this is possible, but definitely something that you would work with your attorney. And then lastly, the young person has to have a visa available to adjust status. So currently, as I mentioned earlier, young people can expect a years-long wait before they can adjust status because of visa caps. Visa caps are annual limits on the numbers of visas available to people in different immigration categories, and they are imposed by law. As I mentioned earlier, while young people are waiting for a visa to become available so they can apply for their green card, they are considered for deferred action, which then allows them to get work authorization for a 4-year period. But for the time being, youth are going to have this long wait before they can get a green card, even though they can still continue to file and have approved their SIJS petitions. So this long wait makes it more important than ever for young people to file their petitions for SIJS as soon as possible, because filing that petition for SIJS is what gets them their place in line for a visa, and also getting SIJS is what makes them eligible for SIJS deferred action. There is a lot of advocacy being done about the SIJS visa backlog. As I mentioned, SIJS was created in 1990, and in the early years of SIJS and prior to 2016, you could go through the entire process, so state court to SIJS petition to green card, in a year or less, sometimes the whole process in 6 months. But because of this growing visa backlog, it's now a multi-year process. So there's a lot of advocacy with Congress to say, hey, this is not how this was supposed to work. Let's get rid of that visa cap for special immigrant juveniles. And a lot of this work is led by impacted young people who have SIJS and are waiting for a green card. So I would encourage anyone who's interested and passionate about this to get involved in this work by joining the End SIJS Backlog Coalition. I'll also mention that on the End SIJS Backlog Coalition website, they have resources that are designed for young people that explain in more detail than I've done today what the visa backlog is, and kind of how to understand the process of figuring out when you might have a visa available to you if you are seeking SIJS. So that pretty much wraps up our material. So I'm going to pass it back to Alonso to talk about how to access legal services for students, and then we definitely have time for questions as well. So feel free to keep dropping them in while Alonso's talking.
Great. Thank you, Rachel. I've learned so much today around SIJS that I didn't know before. And for those of you that are joining us today, and we've talked a lot about connecting with a reputable attorney to answer all of your questions. So the three systems of higher education, California community colleges, the Cal States, and the UCs do offer free consultations and support, especially around SIJS. They are free and confidential and available to all students, faculty, staff, dual enrolled and non-credit course students across the state. They're also able to support with DACA renewal applications, advanced parole, and you can even get your filing fees covered if you're a community college student. So if you go to finderally.com for California community colleges, you're able to enter your zip code and the college that you are attending and be connected and schedule an appointment in under a minute. I will share that the website is going through a little bit of a revamp, so just be patient with the search function. It might take a minute or two for the available appointments to populate, but you should be able to schedule that no problem. For those that are participating from the Cal State system, you also have legal services available. If you go to finderally.com/CSU, you're able to get connected with the legal service provider that's supporting your campus. And if you are from the UC system, same sort of URL, finderally.com/UC, and you'll be guided to the UC Immigration Legal Services there. If you are joining us by a general community member, the state of California also does offer free or low cost, reduced cost application support and consultation support. So I will drop a link in the chat for that, and it'll also be available in your follow-up email. So I encourage you to take some time today. If you are, if you've heard anything that resonates with your specific needs or your specific case, or you want further clarification. I did see some very case-specific questions in the chat, and unfortunately, we won't be able to get to them. But I do encourage you to connect with an attorney who can then answer those questions. With that said, I will I'll have Rachel in a hot seat with a couple of questions that have arisen throughout today's presentation. And I think you've answered it a little bit, but can you share a little bit about why there's such a long wait between steps 2 and 3?
Yeah, I mean, it doesn't really make sense. So that's part of the reason why it's hard to understand. But I think the reality is that back when SIJS was created in 1990, maybe Congress wasn't understanding or contemplating how many young people might be eligible. And so for many, many years, although there was always a visa cap on the number of kids who could get a green card through SIJS, the cap just was never hit. There were fewer young people, than there were visas. But starting in 2016, and there are a variety of reasons for it. It could be more young people coming to the US, but also a lot more immigration attorneys, and a lot more immigration attorneys who know about SIJS doing these cases. So the number of young people seeking a green card based on SIJS went up, and it just continues to go up. And so the visa cap is stuck at the same amount, but there's more and more people applying. So what happens when that happens is it just starts a line basically, and it's a long backlog and it grows. So the solution is that we need Congress to change the law. That there's like a serious advocacy push for that, and I definitely encourage people to get involved in it. That's through the End SIJS Backlog Coalition, but obviously we have a lot of, it's an uphill battle.
Thank you. You also mentioned that they get deferred action after they are approved for about 4 years or so. Is there a case where it could take longer than 4 years for the adjustment to happen?
Yes,
What's it do in
possibly.
that case? Or is that
Yeah.
more of a case-specific question?
No, that's not case specific. So the deferred action policy was only created in 2022. So we're only about 2 years into it. So far, everyone who's gotten SIJS deferred action still has that initial 4 years. However, if we get to the point where people hit the end of their 4 years and they still don't have a visa available, USCIS has said that they will have a renewal process for deferred action and the work permit.
Thank you for that clarification.
Mm-hmm.
We're going to move on to a little bit more of the abused and neglected categories. So one of the questions is what to do when a parent has full custody of their child in their own country. Do they still have to go to juvenile court or can they use like a foreign decree?
So, in order for them to be eligible for SIJS, a state juvenile court in the United States has to make these judicial determinations. So, it's not enough to just have a custody order from a different country. However, definitely, the immigration attorney should know about that custody order. And depending on the exact circumstances, it may be that they're able to just register that foreign custody order in a juvenile court here. And then the juvenile court can issue a modification to that order and then make the SIJS predicate order here. So it's definitely relevant, but it's not enough on its own. Sometimes it even can make the case that's slightly more complicated. So definitely let the immigration attorney know about that.
Thank you. Um, on that same sort of abandonment, if someone was left with their godparents and their parents went back to their country of origin, would that make them eligible?
Hard to say without knowing a little bit more about like what the situation is with the parents, but potentially, and maybe the godparents would be willing to become the child's guardian or the young person's guardian, which they can do in a probate guardianship proceeding. And honestly, if there is a young person living here who doesn't have a parent in the US, it's really a good idea, even outside of SIJS, to have a guardian appointed. So that's worth looking into. And then it will be, just a deeper kind of discussion around what is the deal with the parents in terms of whether or not they meet that can't reunify because of abuse, abandonment, or neglect piece.
Awesome. Thank you. See a couple of other kind of case specific questions. One of them, I'm going to modify a little bit. What if they entered without authorization into the country and the judge terminated the child's asylum proceedings? Would the child need a waiver for grounds of inadmissibility?
I'm going to say that that is a little too case specific for me
Okay.
to answer because I don't know exactly what they mean by the judge terminated their asylum proceedings. I mean, people who enter without inspection are definitely still eligible for SIJS. You could maybe have been denied asylum and still be eligible for SIJS, but I don't know in this what this question has in mind. So I'll leave it at that.
Great. Can you give some examples of how to get some evidence around, abuse, neglect, or abandonment?
Yeah, so our state law actually provides that a declaration from the child or young person can be sufficient evidence in state court. So that would basically be the young person telling what happened to them and their attorney writing it down in a signed declaration for them. And that in and of itself can be sufficient evidence in California. If there is other relevant evidence, like another family member who could write a declaration, or maybe like a news article or something around the country conditions, that can be helpful too. But in a lot of cases, it is actually just based on the child's own declaration of what happened.
Great. Thank you. And I know we have many more questions, and I wish we had more time to get to all of them. But we're about a minute or so away from our webinar ending. And Rachel, I really want to thank you today for all of the great insight that you shared with us, our participants, that I hope you found this very informative. Again, today's conversation was recorded. A link with the recording and the PowerPoint and all of the resources, along with how to get involved with the Backlog Coalition, will also be available to all of you. Before we close out, Rachel, any last words before we close out?
Just a couple quick notes. So just want to again say that, if you're not sure if your situation counts as abuse, neglect, or abandonment, err on the side of talking to an immigration attorney about it, because there are practices that are considered normal in other places, like physical punishment or being made to work at a young age, that might be viewed differently under California law. And what matters here is what California law says. It's not a judgment, it's just how our law defines these things. And if you think there's any chance that you might qualify, don't wait because it's so time sensitive. And then just wanted to share, I mentioned that we have the Immigrant Legal Resource Center where I work has a lot of written resources on SIJS. Here are some links to a few of the resources we have. One of them explains the visa backlog in a little more detail if you're interested in that. And we have a lot of other resources. These are all free on our website at ilrc.org/immigrant-youth. And just thank you very much for the chance to talk about this with you all.
Thank you, everybody. Thank you for joining us. And thank you, Rachel, once again.